What you're going to see next is a post-competency restoration hearing. Now, bear in mind that often both prosecution and defense will agree with the opinion rendered by the psychologist or psychiatrist. If that happens, there's still a hearing. It's just that there won't be any testimony. In this particular case, we're going to act as though there is some disagreement, so we will take some testimony, although it will be very brief.
Court calls criminal case 10-4523, People versus Robert Barnes. Counsel for the people.
Good afternoon, Your Honor. Michael Finkel, Assistant District Attorney on behalf of the state.
On behalf of the defendant.
Good afternoon, Your Honor. Russell Kurth on behalf of Mr. Barnes.
Your Honor, I believe the court has in front of it Exhibit 1, which is a supplemental forensic competency evaluation. The parties have stipulated to its admissibility and to its authenticity. I believe that defense has reserved the right to challenge any and all contents of the report. But, Your Honor, does Your Honor have it in front of you?
Yes, I do. Mr. Kurth, do you agree?
Yes, I do, Your Honor.
Court will therefore receive People's Exhibit 1. Do you wish to present any evidence other than Exhibit 1?
Yes, Your Honor. Briefly, I would like to call Dr. Elizabeth Jenkins.
Dr. Jenkins, please raise your right hand. You solemnly swear, affirm, and penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Once again, please be seated. State your full name and professional address.
Yes, it's Elizabeth Jenkins, Jenkins, and I'm on Unit B at Western State Hospital.
May I inquire, Your Honor?
Please.
Thank you. Dr. Jenkins, I believe you have in front of you State's Exhibit 1, a supplemental forensic competency evaluation.
Yes.
Okay. Are you the doctor? Are you the doctor who prepared this evaluation?
I am.
Were you also the doctor who rendered treatment to the defendant, Mr. Barnes, in this case?
Yes.
And how long was that treatment?
That treatment was a little over 3 months.
Prior to to commencing treatment, had you had an opportunity to meet with and conduct an evaluation of Mr. Barnes' mental condition?
I did, yes.
And as part of this report, did you conduct a subsequent examination of Mr. Barnes' mental condition?
Yes, I did.
Has your opinion of Mr. Barnes' competency or ability to work with his attorney changed between the time of your initial meeting with him and the time you completed this report?
Yes.
In what manner has it changed?
Mr. Barnes, following a little over 3 months worth of treatment, has had significant improvement in his symptoms of schizophrenia and appears at this time to be competent to stand trial.
Thank you very much.
Mr. Kurth?
May I ask my client if he has any questions? Your Honor, we don't have any questions. Thank you, Dr. Barnes.
Doctor, you may step down. You're hereby excused. People have any further evidence?
No, we do not, Your Honor.
Defense, any evidence?
Your Honor, no evidence. I would ask the court to conduct a colloquy to satisfy itself that the expert's opinion is accurate. I will say, in consultation with my client, that he is doing better. I'm very glad he is. I'm not glad about the circumstances under which that arose, his confinement and involuntary medication, but I am very glad that he is doing better today, and I think he may wish to express that to you himself.
Yes. I would like to thank the Lord up above, because I know now that He brought all of this around me, and He brought this whole courtroom into my life to make me feel better than how I am now. And I am completely happy that I'm all around all of these people. So thank you.
Could you tell me your name?
Yes, it's Robert Barnes.
What's your date of birth?
It is, don't know, 28.
It's okay, you're nervous, it's fine.
I was born August 31st. with an 85.
19, okay.
Yes.
And
Yes.
have you discussed with your counsel why you're in court, why you are in court today?
Yes, I have.
And what's your understanding of why we're having this hearing today?
Because of past things that I've done, which I'm very sad to say that I have done now.
Okay. Have you been able to discuss with your attorney the nature of this hearing?
Yes.
Okay. And what is my role? What role do I play in this proceeding?
Here to punish me pretty much for the things that I've done.
Okay. And do you think that your attorney is working in your best interest to help you?
As best as he can, yes.
And do you understand that if I find that you are competent, that we will then proceed to hold other hearings at which you'll be entitled to enter a plea? And have you discussed with your attorney what type of proceedings will come after this?
Yes.
And is there any further? And you do understand the nature of the do you understand the nature of the charges that have been filed against you? Did your attorney explain those to you?
I do now. Yeah. Yeah.
Okay. Do you have any other questions that you would like to ask me?
No, Your Honor.
Okay. Thank you.
Thank you.
You may be seated.
Thank you, Your Honor.
Okay. People wish to say anything further before the court makes its findings?
No, Your Honor.
Mr. Kirk?
No, Your Honor.
Okay. Court hereby finds, based upon the evidence submitted, that the defendant, Robert Barnes, is competent to proceed, and that the defendant is therefore, I believe this case has been assigned over to, let's see, we have this assigned to Judge Smith, and according to my calendar, Judge Smith next has available on Monday at 10 a.m. So the defendant is remanded to the custody to be returned before Judge Smith this coming Monday at 10 a.m. Is that agreeable to counsel?
It is, Your Honor. Thank you.
Yes, Your Honor, it is.
One more thing, Your Honor, and that is, now that my client has been restored to competency, he would like to renew his request to be released to the community on conditions. Don't know if Your Honor will entertain that motion today or entertain it at the next hearing.
People?
Your Honor, we would like an opportunity to prepare a new bail memorandum, and we would therefore ask Your Honor to set it over. We don't need a large amount of time, but we do want to prepare information about release.
In reviewing Judge Smith's docket, it appears that he will have time to do so next Monday, and since it's only a couple days away, the court will deny the request at this time, but we'll note in its findings that that issue should be addressed and that the people are preparing a submission. Please share that with the defendant no less than 1 hour before the hearing.
Yes, Your Honor.
Thank you, Your Honor.
Thank you. We'll be in recess.
Even though this was a very brief hearing, there are 3 points that are well worth noting. The first of those is that the judge conducted a colloquy with the defendant. What that does is it helps corroborate the doctor's opinion that was given in the report. The reason that's important is because competency is an issue that applies at the very time of a hearing, and the doctor's report was rendered several days prior to the hearing, or in some jurisdictions, maybe a month prior to the hearing, which also brings to mind that it is a best practice to advance the hearing as soon as you get the report. Another item that is interesting about the colloquy the judge conducted is that there were some open-ended questions that the judge asked. The defense attorney was fine letting his client speak. That presumes that there is either an immunity statute or an immunity agreement that applies between the parties, in which case anything the defendant says during that colloquy could not be used against him at trial up until the point the judge says, "I find you competent to proceed." If you're in a jurisdiction that does not have an immunity agreement or an immunity statute, the defense attorney may well object to a lot of the questions the judge asked, or may instruct the client not to answer because anything that is said could be used against the client, especially when there's a post-restoration report that opines that the defendant is competent. The final issue was a request by the defense for release of the defendant. The reason that that's interesting is the rules for bail or release are the same whether somebody is mentally ill or whether they are not mentally ill. The illness may provide some aspect that a judge can look at, but the mere existence of a mental illness is not necessarily reason to release someone on bail or to set bail. In this case, the defense was asking for release basically because once the competency issue is eliminated, the argument is that there would be a change in circumstances showing that the defendant is much more capable of coming to court and far less likely to endanger other people, and therefore bail should either be reduced or should be exonerated. So 3 tips, took longer to state than the entire hearing, but they're worth listening to.